Hello, my name is Donna Rogers, and I will be discussing the issue of whether or not an adoptive mother is entitled to maternity leave. I'll be using the grievance discussion case 1 as fact and argument. Next slide, please. The case that I will be discussing today involves Carol Fern, a city employee of Bainbridge Borough for over 18 years. Mrs. Fern is a member of the American Federation of State, County, and Municipal Employees Local 10 Union, which represents more than 50 employees of Bainbridge Borough. Mrs. Fern and her husband were pursuing adoption when on April 22nd they were notified that a child would be available within 3 days. However, Mrs. Fern, being a devoted employee of over 18 years, knew that taking leave during this time frame would pose an undue hardship on the city since it was a busy tax month, and elected instead to defer the adoption for 2 weeks until May 2nd. On April 27th, Mrs. Fern asked for and was granted 2 weeks of paid vacation from May 2nd until May 17th. Next slide, please. The day before her leave was to expire, Mrs. Fern requested 6 months of unpaid maternity leave per the union contract. The Bainbridge Borough Council rejected her 6 months of maternity leave, but instead granted her 2 90-day successive reasonable purpose leaves. Mrs. Fern then contacted Local 10 and filed a grievance with the union against Bainbridge Borough per the collective bargaining agreement that her rights under the union contract had been unfairly denied. Next slide, please. For the purposes of this discussion, I will be assuming the role of the attorney for the Local 10. As attorney in representation of Local 10, it is our contention that Bainbridge Borough did knowingly violate the contract of the collective bargaining agreement on 2 counts, namely Article 10, Section 4.A, Paragraph 5, maternity leave, and Paragraph 1, reasonable purposes leave. It is also our contention that the council, in denying Mrs. Fern her maternity leave, also did violate federal law, namely the Family and Medical Leave Act of 1993. We seek relief and remedy of the grievance through the reversal of the denial and approval of the maternity leave per the specifications of the collective bargaining agreement. Next slide, please. The first violation is in regards to maternity leave. Our findings regarding this portion are as follows. 1, there is no stipulation in the collective agreement regarding the timing or time frame of the request. While we do acknowledge the timing of Mrs. Fern's request the day before her paid leave was to expire, put the city in a difficult position, it was not against the collective bargaining agreement. Number 2, it is our contention that the council rejected her maternity leave simply because she's the adoptive mother and not the biological mother. However, the intent of maternity leave is twofold, 1 being the health and healing and welfare of the mother, and 2 being the care and bonding with the infant. 3, since the care and bonding of the infant is noted in the maternity leave and the intention of, it is the reason why paternity leaves are granted, and it is interesting to note that federal mandate specifies that if a corporation or company has a maternity leave policy, they must therefore approve paternity leave. Given these first 3 findings, it is Local 10's contention that adopted mothers are therefore covered under the maternity leave portion of the contract agreement. Therefore, maternity must be granted to Mrs. Fern, as the wording of the contract clearly stipulates that the leave shall be granted upon the request of the employee. The council cannot refuse to grant this request, whether it be for maternity leave, paternity leave, adoptive, or biological parents. Next slide, please. The second part of the grievance is in regards to reasonable purposes leaves. The first finding lies within the fact that the reasonable purpose leaves are to be agreed upon between the union and the borough council. The union finds that no such notice regarding this discussion was ever received, and that therefore there was never an agreement reached between the union regarding the awarding of this to Mrs. Fern. This act alone is in violation of the collective agreement, and the union charges the Bainbridge Borough Council in acting in bad faith against the agreement and the union, which resulted in unfair labor practices against Mrs. Fern and the union. Next slide, please. Local 10 also charges the council with violation of federal law in regards to the Family and Medical Leave Act of 1993, which clearly allows for the rights of adoptive parents to take up to 12 weeks of unpaid leave. FMLA applies in this case as Bainbridge Borough employs more than 50 employees, and Mrs. Fern more than adequately meets the requirement of 1 year of employment. In addition, Mrs. Fern is also in compliance as she is asking for the leave within 1 year from the time frame of the adoption. While FMLA states that the notice to use FMLA leave is to be given to the employer by the requesting employee within 30 days, it also makes allowances for needs that are unforeseeable. While the union acknowledges that the timing of the request was well below the 30-day window and made it difficult for the city, however, we want to point out that Mrs. Fern herself only received a 3-day notification of the adoption process, and that on her own accord she delayed this for 2 weeks for the good of the city, and that the city was aware of the adoption process, the adoption notification, the deference of the adoption for 2 weeks, and therefore it is our contention that they should have been expecting and anticipated a possible extenuation of the leave regarding these circumstances. Next slide, please. In keeping with the terms of the collective bargaining agreement, Ms. Fern approached Local 10 to file the grievance, which we have filed against the City of Bainbridge Borough and are still awaiting a response. As per union notification process, we have also notified the national union regarding the grievance that has been filed locally, so that should it become necessary to escalate the grievance, the union is already notified of and has been kept apprised of the events. Should it also become necessary to file a grievance with the National Labor Relations Board for unfair labor practices, it will be the national representatives who will undertake this grievance process for Mrs. Fern and Local 10. In addition, union representation may find it necessary to file a complaint with the Wage and Hour Division of the Department of Labor. This filing can be done concurrently during any part of the grievance process. Next slide, please. Should the grievance process become stymied within the union process, or the outcome is not favorable, the union will advise Mrs. Fern that she can sue the employer herself, but should retain her own lawyer to do so. While historically the courts have deferred to the union management arbitration and grievance process, it has become very apparent that some employees are not receiving fair representation and may need the protection of the courts in order to assert their rights. Employees who feel that their employers have breached the collective bargaining agreement may file suit in either federal or state court under Section 301A of the Labor Management Relations Act. Since 1955, the courts have continually revised the parameters for bringing suit in court, with the current consensus allowing for either individuals or the union to bring a federal suit against an employer once the grievance process has been exhausted. However, when an individual's civil rights have been violated or when a wage and hour claim has been alleged, the employee falls under the exceptions that have been predetermined by the court, and the employee can bypass the entire grievance process. It is of note, though, that an employee who chooses to bypass the grievance process must bring strong, clear, factual evidence to court, and it is therefore advisable that an employee seek redress and remedy through the grievance process first. Next slide, please. In summary, it is Local 10's contention that Bainbridge Borough did knowingly violate 2 points of the collective bargaining agreement, as well as violate federal law as it pertains to FMLA. It is our position that Bainbridge Borough should immediately rescind its earlier disapproval of the 6 months of maternity leave and grant the request retroactively to May 18th with all protection for wage, job, and employment security intact. Furthermore, it is the intention of the union to continue to escalate the grievance up to and through the courts if necessary. Thank you for joining me today in our discussion of adoptive parents' rights in the maternity leave.